someplace over $100,000, and then get rid of the moonlighting and the quid,
that's going to significantly reduce the prospect of a conflict of interest.
Right.
Full-time, banning all outside employment. It would eliminate sort of the opportunity for conflicts in consulting businesses. I mean, it's still floating around out there. All those lawyers up there, and really nobody in the public knows who their clients are, what they're paying them for,
because they don't have to.
Yep. That's right there in hiding in plain sight.
Well, let's ask this: what are you? What's your prediction of what happens? Does the prosecution bother to go back and try and retry this case, or have they made their point? We're talking about an 81-year-old guy. They tried all the headlines: Albany on trial. Right. They made a point about corruption. Albany's a cesspool. Albany's terrible, etc. They held the guy up as poster boy, Exhibit A. If he does time or doesn't do time, it's over. They got their hide. He's out of office. It's done.
I think they used the best ammunition that they had, which was this statute. If they had something else, if they had something better, they would have used it. This is no shock that there were problems with this statute. They knew this going in. And in fact, as soon as there was an indictment, there were all kinds of motions by Joe Bruno's lawyers saying that this statute had problems, all kinds of constitutional problems. Right. So it's no surprise, but they still went forward with this one. They probably figured this is the only one they actually could use, or the best one they could use. Anything else is going to be worse than this.
And the judge also specifically said to the jury, this is not a case of quid pro quo during the trial.
No.
That's not what this is about.
And it has to be that.
Right. It has to be that according to this ruling.
Yes.
So do they then go back and bother, in your opinion?
No, there's a couple paths that they can take, okay? They can, because the case is currently on appeal, they could, if they were to agree to it by stipulation, by agreement, have the case remanded back for further proceedings in the district court. Right. And then have a conference with the judge, make an evaluation of it, and decide whether or not this thing's going to go forward at all. Right. Or they could take the position that, hey, the Supreme Court didn't decide your case. It's on appeal. Finish the appeal. Go talk to the Second Circuit, which is the appeals court for the Northern District. Right. And, we'll see in 9 months when we get a decision. And if the case gets reversed, then we'll make a decision then whether we'll go forward.
And what's the Second Circuit going to say if they do that? They're going to say to the prosecution, what are you doing here? Why didn't you take care of this at trial?
Right.
I mean, this is pretty clear.
Well,
you have proof of bribery here. You have proof of the kickback. Why are you wasting our time? I think that's what would happen. I don't think the Second Circuit would be happy.
No, I don't think they would be happy. I think the question would be, if they got the case, would they remand it? Right. It's going to come back. It's going to be reversed. Right. So the question is it reversed and, figure it out for yourself, or reversed and dismissed and we figure it out for you?
But how much of it actually has to do with ego at some point? Because, again, I mean, you're talking about, and I don't want to harp on it, but he's 81 years old. I mean, he would kill me. If he's watching this, I'm sorry, Joe. But really, I mean, the guy he's not young. It's going to take a long time. When do you decide, okay, you know what, we made our point and we quit while we're ahead?
Well, you have to ask the U.S. Attorney's Office that. From my perspective as a former prosecutor, the bottom line is this: they took their best shot. He was acquitted of more than he was convicted.
Right. Yeah.
Okay.
Right. Five of
the jury was apparently ambivalent. They apparently personally liked the guy, but thought that this deal with Jared Abruzzese stunk, and so they convicted him of this. And now that conviction is in jeopardy. It's almost like you say, okay, this we made, like you said, we made our point. Don't do it again.
And the judge wasn't enormously fond of Bruno, it didn't seem.
No, and the instruction he gave to the jury, it seems to me he went a little bit overboard. I mean, he said conflict of interest, or clash of interest, or any appearance of a clash of interest. Where do you get that from this statute? The statute doesn't even suggest such a thing. He's pulling that out of language from some other cases.
Yeah, it also seems, though, it's very difficult, I think, when you read this case, and I'm not an attorney and not schooled, but when we talk about, what went on here,
right.
It looks like something was wrong. And you also, we're talking about the Skilling case, that's the Enron case.
That's right.
And that actually had some glaring...
Well, it's interesting because, I mean, sure there may have been some things, quote, wrong, okay? The question isn't whether or not something's wrong. The question is what's the appropriate penalty for the wrong. And under state law, the penalty is pretty small, okay? And under federal law, the penalty is pretty big. I mean, it's a 20-year felony.
So that's why you go to federal court.
So
right.
Then the question becomes, if you're going to impose that kind of a serious sentence on it, you probably should have a little bit more meat to the case than just a conflict of interest. So, there should be a little bit more. We should be talking bribes, kickbacks,
Right.
And I think that's what the Supreme Court said, is that if you're going to subject somebody to that kind of a penalty, there better be something more to it than just a conflict of interest.
And Paul, you're going to get the last word on this one. I want to thank you very much for coming in. Vin, thank you very much
Great
for coming in.
Great to be here, as always.
We'll have you in again. Thanks so
Sure.
much.